Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers. Today we're reacting to another update of Young Thug. Young Thug, as you know, was taken into custody on a RICO indictment. 28 people in total have been taken into custody. Now, there have been some developments since he was taken into custody. First, his lawyer, Brian Steele, has filed an emergency motion for his release, stating that there are dungeon-like conditions in the jail, and nobody likes jail. Nobody. And jail's not meant to be comfortable. Here's the thing. I've seen people argue how awful the county jail was and how bad their staff was and how they don't get medical care and all this stuff. And when you're saying that, guess what? A deputy's sitting right there, and they're the ones in charge of the jail, and they're the ones who are charged with giving you care while you're in jail. A judge saying that there are dungeon-like conditions, so I'm not going to release you, is not a reason to let somebody out of jail. Jail's unpleasant. There's just no two fucking ways about it. Jails are just simply unpleasant. They're not meant to be pleasant. But there's two reasons why you should hold, that the court takes into consideration any kind of conditions of release. One is risk of flight. And if you have means and you have a passport and you have a big case, so you're looking at life, the other thing, the punishment that you're looking at is also factored into. What is your incentive to stick around? If you're looking at a couple years, that's different than if you're looking at life. And if you're looking at life, they look at two things. They look at risk of flight and harm to the public. So when you have all kinds of weapons seized and drugs seized, that's a consideration that the court makes. The court isn't going to say, well, the jail's uncomfortable, so we should release you. Not a persuasive argument for the court. So let's look at and see what happens at his bond hearing.
Good morning, Mr. Jeffrey Williams. My name is Judge Rashida Oliver. You are here on a bench, what we call our benchmark calendar for Fulton County Superior Court. Be aware that on this calendar, you are here because you have been indicted under 22 SC 182273 for conspiracy to violate the Racketeer, Influence, and Corrupt Organization Act and participation in criminal street gang activity. I brought you forward so that you can be put on notice that for the felony charges that you receive, you are to be presented before the judge, Honorable Judge Earl Glanville, at the next available calendar that will be presented in courtroom 8F at 9:30 a.m. The date at which you are to appear at this time, I am not aware of. But be aware that you have the right to remain silent and not incriminate yourself while you are there, and anywhere else anything that you say can be used against you. It is my understanding that you are being represented by Attorney Brian Steele, and the District Attorney's Office, Don Geary, are also on. So I wanted to make sure that you were fully aware of that. ADA Geary, is there anything else that you would need to add? And then I will hear from Attorney Brian Steele.
Judge, respectfully, I think you've already stated that there's not a bond issue. There's not really a first appearance other than you're verifying his counsel, which would hand.
So the criminal procedure that he's talking about, this is just his initial appearance, just to get before a judge. There's what you call your first appearance. At your first appearance, there's two things that happen. They read the charges to you, and they determine conditions of release. This is just an initial appearance before the magistrate.
Handle the first appearance issue. One thing I want to put on the record, Judge, and thank you for giving me the opportunity, is at an appropriate time, we're going to file an objection or notice of objection to Attorney Steele. While he's a brother attorney, he has represented multiple people on the indictment.
Now, that's another. So they're going to try to kick Steele off the case. The reason being, you can't serve two masters. In other words, you can't represent more than one client in the same criminal case. It's just any lawyer that does that is a lawyer that's really not doing something that they're supposed to do. And that's why they're talking about there's a conflict. So, for example, I represent Joe and Steve, and let's say in the same criminal case, and Steve wants to cooperate against Joe. Conflict.
And we feel that a conflict would exist, and we just want the record clear on that. At the appropriate time, we'll move forward with that.
All right, anything, Attorney Steele?
Good afternoon, Your Honor. Thank you so much, Mr. Williams. Your Honor, I do represent Mr. Williams. I've entered, or should be entered, an appearance as counsel. My understanding from Uniform Superior Court Rule 26.1H, as in Hillary, that at the first appearance, this honorable court shall consider bond if the offense is not one that is bondable only by a superior court judge. I heard what you said as well, but the offense here is Mr. Williams is only indicted on count 56 and count 1, which is a criminal street gang activity and a conspiracy to commit racketeering. And both of those, I believe, are within your breast to set bond, and I would like bond to be heard by your honorable court.
Now, at the time he's making this argument, there aren't any other charges yet.
As far as conflict, I'm sorry.
No, go ahead, thank you. And certainly,
As
go ahead, Attorney Steele, I want to make sure I hear you out.
Okay, Your Honor, thank you. And as far as the conflict, Mr. Geary, as well as District Attorney Willis have explained that to me, and I believe that if they file the right motion, a hearing will be held. And under the law, this is not an actual conflict of interest. It is a potential conflict of interest which can be waived, and I believe that will happen.
All right.
So what that means is he's represented some other people who are probably on the indictment, and so it doesn't create an automatic conflict necessarily. And as long as he's not representing the other people now, and as long as he can't use anything in his representation of that person that the conflict is supposedly there against him. So that would be, so that's what he's talking about there.
Thank you. Attorney Steele, I certainly understand, and if I were sitting solely as a magistrate, I believe you would be correct with the stating of the law itself. But as I am sitting as Superior Court Fulton County delegated judge, there's a specific delegation order for which I am operating under that indicates that the authority to set bail is simply not delegated for any case, regardless of the charges involved, that has been indicted and assigned to the docket of the Superior Court judge. And that is the order in which I am following. And so because I am doing so, I'm not at liberty to do a bond unless I have some additional authority to do so. And at this time, I do not. So unfortunately, you will have to submit your motion for a bond directly to the Superior Court judge that is handling this case, which is Judge Earl Glanville.
So what they're talking about, like in our jurisdiction, you just have district court judges. In federal court, you have magistrates, and then you have your district court judge. The magistrate generally sets a bond, and if you have or doesn't set a bond, and if you have a problem with it, you can go to the district court judge. Here, she's saying that she doesn't even have the authority to set bond, and that it has to be set by a superior court judge.
So,
Do it, Your Honor.
right, certainly. So the order of the court on today is that he's been put on notice. He's not gotten a first appearance in that particular situation because he is indicted. He is not subject just to a warrant, and it was not a warrantless arrest. So that is where we stand at this time. Mr. Williams, I'm sure your attorney will reach out to you and give you further indication of what needs to happen in your case.
So that was his first time in court. So shortly after that appearance, Mr. Williams appeared in front of another judge, and that judge also denied him bond. But bad news for Mr. Williams is that a search of his home was conducted, and as a result of that search, he got, I think, 7 new charges. So, and those included possession of marijuana with intent to distribute. Who cares? Nobody cares about marijuana. Possession of a Schedule 3 or 4 controlled substance with intent to distribute, i.e. lean, a lot of lean. Possession of a firearm during the commission of a felony, in other words, possession of a firearm while you're possessing drugs. Possession of a sawed-off shotgun, sawed-off rifle, machine gun, dangerous weapon, or silencer. Unlawful for a person empowered by or associated with a street gang to conduct, participate in criminal activity. So what we have here is we have 7 new charges. And one of the things, remember what I told you, that a court looks at the risk of public safety. Well, one of the charges is possession of a sawed-off shotgun, sawed-off rifle, machine gun, or other dangerous weapon or silencer. That is possession of a firearm equipped with a switch. We know what a switch is? Of course we do. A switch is a block that you put on a block, and it prevents the slide from locking, and it makes a semi-automatic handgun fully automatic. Highly illegal, and I guarantee the feds are looking at this case. I would find it hard to believe that they're not. So if you were just dealing with the RICO in a historical context, the bond wouldn't be that big a deal. But when you have current search warrant that links him to criminal activity that is not only drugs, but also firearms that are really, really dangerous, the judge denied him his bond. And here's the other thing. In this case, there's evidence of wiretaps. And obviously, we don't know everything. But some of two of the snippets, y'all ain't beat him up yet or shot him, y'all getting soft. It sort of looks like he's directing things in a sense. And, I'm just saying what I think right now, and what I think is based on, very little information. It's just public reporting, basically. But I did find something very interesting that the District Attorney Willis had said in a press conference. She said at least 10 of the 28 defendants have been arrested, and some of them are facing life in prison if convicted, which I said in our prior video. Willis was asked about her decision to use Young Thug and Gunna's often violent lyrics against them in court. What have I told you before? This is self-snitching, right? She said, while she recognized this is straight from a district attorney. While she recognized the First Amendment is one of the most precious rights, she noted free speech does not protect someone from having their own words become evidence in criminal proceedings. Period. This is exactly what I've been trying to warn guys about. Just be careful out there. Be careful what you're doing. Build, and we'll bring you more reactions. But this is just a quick update on what's going on with Young Thug. He ain't getting out of jail. Gunna ain't getting out of jail. He was denied bond as well. Let's hope his lawyers are able to put together an excellent case. It does not look good for him, but let's cross our fingers because I don't like see anybody go to jail personally. It just goes against my nature. But let's hope that he has got a great defense. He's got the means. So this has been Bruce Rivers, Criminal Lawyer Reacts. We'll see you next time. Make sure you subscribe. Follow us on Instagram. Follow us on Twitter. Sign up for Patreon. You can help somebody get out of jail that way. And we'll see you next time here on Criminal Lawyer Reacts.